Hi, Douglas Rosenthal of the Rosenthal Law Firm with you. Today I'd like to discuss with you an actual case that I have handled today and argued before the Kings County, New York Supreme Court. This was a matter in an Article 78 special proceeding. Before I explain to you the particulars of the case, perhaps I should explain to you a little bit about what an Article 78 special proceeding is. An Article 78 refers to a particular section of the Civil Practice Law and Rules of the State of New York. It particularly refers to the Article 78, which is like the chapter number of it. It is the section of the law. And what it allows you to do is to bring an action before a Supreme Court judge to challenge a final administrative agency ruling, a final administrative agency decision, on the basis of whether or not that ruling was made in an arbitrary and capricious manner. Now, my client was a sanitation worker for the City of New York. On September the 5th, 1995, he was on what they call basket patrol, meaning he was lifting litter baskets on the corners of city streets, and he was putting them into a garbage truck that he was working with. At that time, he lifted a basket on one of the corners and felt a sharp pain in his back. Thereafter, it was discovered that 2 car batteries had been deposited in that litter basket, as well as a wrapped up bundle of heavy magazines. That added approximately 35 to 50 additional pounds of weight to what a typical basket should have weighed, causing him to injure his back. Thereafter, he applied for disability benefits, which at that time would have been 1/3 of his salary had he been on the job for 10 years or more and could not have proven that the matter that was involved was an accident. He was examined by a medical board about 6 months later in 1996, and they found that he was eligible for disability benefits because he was a member of the sanitation unit for 10 years, but not because the matter was an accident. My client at that time didn't challenge the matter because there was no reason to challenge it, because there was no difference in benefits as to whether or not he was going to get benefits as a result of his being on the force for 10 years or because it involved an accident. However, here comes the wrinkle. In the year 2002, Governor Pataki signed a new law, and that law was known as Section 605-B of the RSSL, the Retirement and Social Security Law, which allowed 3/4 benefits if in fact you were disabled as a result of an injury which was part of an accident while you were working. My client at that time filed another application for benefits under 605-B RSSL, looking to prove that he in fact suffered an injury as a result of an accident because those car batteries and the additional weight as a result of the magazine should never have been in there, and that was an accident. He could not have expected that additional weight. That weight was a risk that he did not plan on and should not have planned on because they did not belong there. As a matter of fact, it was illegal for whoever put those into that basket to do so. To make a long story short, the standard for deciding these cases is arbitrary and capricious. I argued this case on behalf of my client today, and I leave it in the hands of a Supreme Court judge in Kings County for a decision. I share this with you because I want you to know that our office represents such clients in Article 78 special proceedings. The procedure in doing so is to file a notice of petition and petition within 4 months of receiving the final administrative agency decision. We would be happy to assist you and represent you in an Article 78 special proceeding if you believe that you are eligible and qualified to file such a proceeding. In order to do so, you can call our office at the Rosenthal Law Firm. Our telephone number is 212-625-8300. Our offices are located in downtown Manhattan, New York City, and we are available to take your phone call and answer your questions. We look forward to hearing from you. Thanks so much.